Good morning, ladies and gentlemen. This is Mike Lilly. The class is Criminal Procedure and Evidence. This is actually the 36th and last lecture of the semester. And a few things we have to do today: a brief review and setup for the final test of next week. And second, the big reveal as to the grades each team has earned in yesterday's very well done mock trial competition. I will also, of course, have to give my usual remarks as to the trial and other things about it. And so we'll proceed from there. First and foremost, the study guide for the mock trial final exam is posted. It is on the Moodle website.
Can I get one?
Yes, ma'am. I got a bunch of them. And one of my purposes here is to quickly ask if there's any questions about any of these cases that you'll want me to look at and cover during this class. Let's get over to the thing which most of the students here are very antsy about. Their knees are starting to quiver and knock. It's simply over the fact of how well did you do. The big reveal is that I believe this is one of the best mock trials I've had in many years, and for that reason, therefore, each side receives a grade of 95 on the mock trial. That is each team, each member on each team. And now I recognize that one team had 8 people and the other had 5. But I can tell you that any person who did not appear yesterday, there are issues. And I won't answer further. So let's talk about some brief remarks. I think Judge Sadler did very well. He talked a lot about the case and different things, which I've tried to beat into your all's heads over the days. It is unfortunate we didn't have any extra people to give me a jury, but I think basically you understood the concept that in a trial for first-degree murder, there are 4 possible verdicts. Right? First-degree murder, second-degree voluntary manslaughter, and in some rare cases, involuntary manslaughter. And we've actually had a jury in a first-degree murder case here in Mercer County in the last 2 years convict a person only of involuntary manslaughter. And there was an issue again of self-defense. So it's possible that can happen. Yes, and I have to confess, I did find it interesting to read about the differences in the penalties from past and prior. I was still thinking that second-degree murder carried an indeterminate sentence, and now it's not, which I think makes a major difference when it comes to plea bargaining offers and agreements. Since basically a prosecuting attorney can simply, make a deal and give a determined or a set number of years for service to be served, which is, we all know, basically means that they can get an early release from prison. The number one complaint I had about the prosecution's very good effort, you forgot to introduce physical evidence. You had Chloe Spade, who did an excellent job as a forensic investigator, but you didn't ask her about your all's pictures of the footprints, which to me was a key issue in the trial, linking this reprobate over here, Johnny Stiletto, who I really didn't recognize with his dark glasses and all yesterday. very well. And Johnny, I might add, did a great testimony on the stand. At least he didn't bring a bottle of liquor with him, which I've had some people do in similar cases, right? You know, hey, I'm still on a drunk today, you know. We didn't have that happen, but yes, there is little of any doubt that he didn't enter his physical evidence. What about the murder weapon? You had it sitting there in front of you. I didn't understand it. Likewise, this thing that y'all argue about so much, left to right and right to left, what difference does it make? You referred to it in your closing argument, but you needed to have a forensic person say, wait a minute, Mr. Stiletto is either left-handed or right-handed, which makes a difference as to how you use the knife. And I'm honest, interestingly enough, most people who are right-handed use their left hand for a knife. I'm left-handed and I use my right hand for a knife, which is why I'm always cutting myself. That's neither there. But that's, you know, part of it. But that again could have been a key factor in if this were a real prosecution as to cause of death. Defense, here was a genuine thing that you could have questioned and should have questioned when you had that forensic investigator up there about her findings, you know, left-handed versus right-handed. I mean, I know you asked how was the victim dispatched, but you shouldn't asking, well, doesn't this imply that it was a right-handed offender who committed this crime rather than a left-handed offender? And you should have objected when they attempted to bring in this physical evidence they had during a rebuttal, because that's something that has to come in direct evidence. And again, had you merely said, I object to it, Sadler would not have allowed it in the trial. And that's, again, a golden opportunity, which some people miss. I was real curious about hearsay evidence or things of that nature. Rarely did I didn't see any real objections, you know, no relevancy, no this, no that. Anyway, I was also somewhat surprised about bartender's testimony or evidence, since I kind of gathered that there would be somewhere in the fight, there was a confrontation or a fight between the bartender and Stiletto, which must have had some bearing in the case. Yet when our bartender testified, didn't hear anything about it. Oh, he was just there having too much liquor to drink. I think also you could probably have used one of the police officers to talk about the distance between the murder site and the bar. You know, how many miles was it? How many feet was it? How long does it take someone to walk between one place or another? And again, that's a defense argument, because all you really would have to say is, wait a minute, okay, if he was gone for 20 minutes, and make more of the fact by using police and law enforcement people to show exactly how long it would take to get from there and back again. Finally, prosecution, when they're raising that issue, that he was in the bar, slipped out for 20 minutes to go murder the lady, you should have raised the issue, well, if he was drinking that much at the bar, how could he, as a non-sober person, do anything? I mean, I know that you always have strange cases with drunk drivers who survive miraculous wrecks because they are over intoxicated. But most drunk drivers don't drive very well. And if he'd really been there slugging them shots down all night, he's probably seen double or triple by the time he's supposed to have snuck out of the bar. Again, an issue to be raised about that. However, let's look at the positive side. Both sides had prepared all of their witnesses very well as to what they wanted them to testify. I did not see any major slip-ups with people, and it was one of the reasons why this trial lasted as short a period of time as it did, is because we didn't have the cross-examinations from both sides were pretty short normally. I really expected you all to start digging in more to some of these people or some of the issues. But at any rate, this trial basically didn't even take an hour to complete. And normally, I figure in an hour and a half to 2 hours. The lady from the newspaper arrived right at 11 o'clock or something. I met her down in the hall. She's expecting to have a newspaper article on you, but of course, it was all over by the time that she decided to get there. I speak no more about it. She said, "Oh, well, I thought this trial was going to last till 11:30. Well, that's not at all what Judge Sadler really expected. Anyway, so I'm sorry you didn't get newspaper coverage. You'll see other coverage, including, I think, a 45-second spot, which is going to be online about this case. For those who want a copy of the digital review recording of this trial, simply go talk to Mr. Connors over in the ITC Center, and he can make arrangements on it. No, you don't have to pay $50 or $100 to get that. It may take them a day or two to make it up because they're so heavily involved with preparing for graduation, but they'll get you one made. Providing, of course, that your computer has a DVD drive, that can show the trial. Once again, I have them all recorded because I do tend to like to show them to other students, but also I think you all deserve, to get a chance to see how things were or not. I guarantee you'll see lots of faults that you think should have done, or you should have spotted, or you should have thought about if you watch the video, as opposed to comments. I noticed a few things you're already talking about today. A few things you should have hit or should have spotted. It's just even in a real trial, there's often lots of things that both sides miss. And when people go back and talk to jurors about why they decided a case like they did, it's really a lot, oftentimes simply because they think one side or the other didn't do what they said they were going to do in their opening remarks. Your opening remark for the defense, very, very good. Covered every base you could cover. Now, the prosecution never has to give too much of an opening remark. All they really have to say is, so-and-so died a brutal death, and this cat over here did it, and that's the way it is. However, I compliment all of you all because I think you all did a very excellent job. One of the best mock trials I've had in a number of years. All right, let's talk about test review. First of all, there will be 30 questions on the final exam. One question from each of these 14 cases. Some will have more than one question, but every case, every one of these 14 cases, there will be one question asked on the exam, and I can't tell you whether it's multiple choice or true false. Okay, I leave everything open regarding format of the test. It may all be multiple choice, true false. It may be different things. The only thing it won't be is essays. Why? Because I don't have time to grade them. And what is the exact date of this case?
Wednesday at 8 a.m.
Wednesday at 8 o'clock a.m. That's right. So get yourself up about an hour early and show up for class. Make sure you bring your pencil because it's going to be taken on Scantron sheets. Once again, so I can get them graded and up. Final grades are due this semester Monday at 10 o'clock. That's Monday after graduation. I'll have my grades in probably by Friday at the best. I will be here on campus at 10 o'clock that Monday. And if you want to call me on the phone, I'll be glad to give you your grade. One thing they do in the registrar's office is normally they release grades in a class. As soon as they have final grades for an entire class, it gets put up online, so it'll come out. Used to be they all waited until everybody sent their grades in. Nowadays, it's not necessarily so. However, because of privacy requirements under HEPA, the HEPA law, I am forbidden to post grades in any format or shade because someone else may be able to find out what your grade on this test was. Despite the fact that normally, what do I see? Since the student gets their paper, what do they immediately do? Share it to everybody sitting around them, right? I mean, there's really not too many secrets. So I pass that on. Just make sure that you all, anyway, I can talk to you about your final grade in the class and any other grades you may question. We've handed back our other test grades in this class, as I recall. Okay. Any of the cases on the study guide that you're all curious about?
The Castigar versus U.S.
Castigar. That's the case involving immunity from prosecution. Let me see if I can figure out which, I can't remember what page it's on. Essentially, it is a case involving what can prosecutors do when there is a grant of immunity from prosecution. That's on page 910 in your text. And yeah, it's an old 1972 case, but it's the first case the Supreme Court ever really decided in more recent times about immunity from prosecution. In this particular case, the government had subpoenaed Mr. Castigar to testify in front of a grand jury. He refused. So to make him do so, he was granted against his will immunity from prosecution. He appeared. Okay. He appeared but refused to answer, asserting his Fifth Amendment rights. And at this particular time, he claimed the Fifth Amendment, held in contempt, sentenced to prison. And the question in this particular case is, if one is granted immunity from prosecution, can they be made to then testify? And the court says yes, because they can no longer incriminate themselves. Okay? You understand what the concept is?
Yeah, but that's where you can be granted immunity from certain things in a case, but
Yes.
whenever they would dig and find something else against them, they can still get it.
That's right. And that's the one problem with a grant of immunity. There are two types. It's called general, and then there's also called transactional. And transactional is just a crime that you were being required to testify about. But there could be lots of other things that you've done, which you may talk about, not thinking about the fact that they can prosecute you for those separate offenses. And again, these simply are differences in the way things look. So anyway, the Castigar case sets up that key issue that a person under immunity from prosecution can be forced to testify at least about whatever crime or crimes they were granted immunity from. Very few people are ever granted blanket immunity, meaning anything they've done, murder, rape, whatever, they can never be prosecuted for. Most federal and state prosecutors want to limit what that grant of immunity is. And I might add, by the way, that that's also one of the things that if you have a plea bargain agreement, it's always in it that you write that you're granted immunity from prosecution for for the crime you've been charged with, and therefore can be made to testify. Next. Speak now, forever hold your peace. No more questions? You all are easy to please today. All right, well, these are the cases, each and every one. We've talked about each and every one this semester. I forgot to look and see from which numbered lecture to today we had to look at, and I can't answer that. Anyway, I'm sorry, I just have to look for it. Basically, it starts, I think probably your March. I think it's in March we start talking about this. We start talking about, we already spent a lot of time in the test about evidence and electronics and all that, and then we start talking about Miranda in these cases. So with that in mind, therefore, unless there's no further questions of me, this is your one last chance. I would also comment that I am aware that the evaluations by students, I think, is still open. If you wish to avail yourself of that, I'm really always surprised how few students do, unless it's someone I've given a bad grade, has gotten a bad grade out of my thing. I don't want to say that I have given a bad grade. I don't give bad grades. You earn them. This isn't a candy store in which I'm giving out free samples. So, with that in mind, it's been a very good semester this year. Appreciate all of y'all's effort and help in doing the class. And depending on how well you do next Wednesday, I wish each and every one of you a very good final semester. Very good summer. I guess I get 2.5 months off. If you're taking summer school, you get a week off after graduation. With that in mind, then I'll see some of you all next semester. Others maybe later. So long.